In this video essay, our group will critique the overall outcome of the case Masson v State of Queensland 2018 and the appeal in 2019. This case was brought to trial to challenge the treatment pathway chosen by the attending paramedics. In 2002, the late Jennifer Masson suffered a severe asthmatic attack, which resulted in QAS being called. On arrival to the hospital, Jennifer deteriorated significantly and suffered irreversible brain damage as a result of deprived oxygen. The plaintiff, the estate of Jennifer Masson, has decided to hold the defendant, State of Queensland, accountable and become liable for negligence for the patient's care. Negligence is the area of law that addresses liability when one party does not perform in a reasonable manner and damages occur. Although the law of torts for negligence had not come into place when the alleged offence occurred, and therefore wasn't exactly tried in the cases, it still accurately applies. In the aforementioned cases, negligence has occurred in the eyes of the appellant when the paramedics from Queensland Ambulance did not administer adrenaline in a timely manner to a patient experiencing a severe asthmatic attack. The alleged result of the negligence was irreversible brain injury due to oxygen deprivation. In an entry to the Torts Law Journal, negligence consists of the elements of duty, breach, and causation of damage. In this case, the appellant alleged that the paramedics owed the patient a duty of care once they took on the role of treating the asthma attack. They then breached that duty of care by not administering adrenaline in a timely manner, and by doing that caused irreversible hypoxic brain injury. Some key issues have been identified in the cases through critical analyses. Firstly, the term asthma extremis. Based on the information on QAS CPM 2002, would it have been starkly apparent to the involved paramedics without knowing any background of the patient that she was indeed an asthma extremis? Critical care educators define the asthma extremis as only clinically identified by an increased partial pressure of CO2 in the blood and requiring mechanical ventilation. By this definition, there is no possible way that the paramedics on scene could class Ms. Mason to be an asthma extremis. Secondly, the medical experts were not in agreement of the medication to be used for Ms. Mason. There was essentially a disagreement between old and new educations as to whether salbutamol adrenaline should have been the first-line treatment for severe life-threatening asthma. If the experts cannot agree, is there even a correct answer? It was identified that the initial management of Ms. Masson was in an attempt to rectify the oxygen deficit. Furthermore, the 2002 guidelines clearly state that adrenaline is indicated for cardiac arrest, not for severe asthma, which is what occurred for Ms. Masson. Another issue to be explored is if the treating paramedics directly caused the bilateral pneumothoraces. This raises the concern if the paramedics indeed ventilated the patient at the correct rate of 4 to 8 breaths per minute, or if they had ventilated at a higher rate which directly caused the barotrauma. In the case, the judge states that the standard of care under consideration is not as high as that expected of a medical practitioner or an emergency physician in the hospital setting, but of an ambulance officer operating in the field of an emergency. 2 out of the 8 expert witnesses, Jack Keneally and Tony Hucker, were the only experts in the field of paramedicine. The other 6 are expert medical practitioners in a hospital setting. This appears to be contradictory to what the judge stated. It is interesting that doctors and specialists are being used in a case against a paramedic. As Byrne states, you wouldn't get a general practitioner to comment on a negligence case regarding a surgical doctor. Both may be doctors, but are involved in different aspects of patient care in different environments. Experts should be qualified within the relevant field in order to comment on a negligence case. In this case, doctors who practice inside a hospital within a multidisciplinary team are commenting on paramedics who work out of hospital on their own with a less extent of training than doctors. Therefore, the standard of care must be decided reasonably by other paramedics. In this case, both of the paramedics agreed that Mr. Peters recognized the severity of Jennifer's condition and that salbutamol was an appropriate drug of choice considering her condition. The majority of the doctors and specialists concluded the complete opposite.
It is the preparation and practicing differences of paramedics that renders the testimony of medical emergency practitioner expert witnesses unsuitable in this malpractice case. Primarily, the course of education and training each profession receives discerns the decision-making skills of the professional in pre-hospital versus hospital environments. Paramedics are specifically trained to respond to potential dangerous situations in a time-sensitive manner. While paramedics are well equipped for this, it is only fair that the judgment of paramedic actions should be made by a professional with the ability to understand such differing context. The Bolam test advocates for this to have reasonably similar practicing healthcare workers to properly judge the facts of a case as expert witnesses. As Josh Doot states, the law has already been determined by the duty of care. However, the standard of care received should be reviewed by more applicable candidates relevant to the paramedic field.
Was the time of initial treatment too late for the injury to be avoided by administering adrenaline? The judge decided that the patient's hypoxic brain damage occurred after the defendant arrived on scene and before adrenaline was administered, and believed that it was not too late at the time of initial treatment for Miss Masson's injuries to be avoided by administering adrenaline. The Civil Liability Act 2002, Section 5E, outlines that In proceedings relating to liability for negligence, the plaintiff always bears the onus of proving, on the balance of probabilities, any fact relevant to the issue of causation, and this was not done. Expert witnesses were conflicting in their opinions as to when hypoxic brain damage could have occurred, with none being able to give a definitive time, failing to establish that the emission of adrenaline in initial treatment caused the injury. For a judge to decide that the emission or timing of an ambulance officer's administration of a particular drug was negligent and sufficient to determine causation brings about a precedent for the court to implement a time frame of when ambulance officers should administer treatment without taking into consideration the emergency setting as well as the specific details for each patient and case. The Civil Liability Act 2003 and Law Reform Act 1995 outline the protection from liability for a medical officer providing care in an emergency setting where an act is omitted in good faith and without gross negligence or reckless disregard for patient safety. Ultimately, causation and liability should not have been assigned to Mr. Peters.
The main argument of foreseeability is whether or not an ordinary person in the situation, and therefore the defendant, could have reasonably been expected to have taken further actions to prevent the resulting damages. Mr. Peters suggested that since there was an increase in Miss Masson's respiratory rate following the initial salbutamol, her condition was improving and therefore needed no further escalation. Expert witnesses called for the appellant's case, however, concluded that Miss Masson's respiratory rate remained below optimal and showed no substantial improvement, excluding her loss of central cyanosis. In the case of Wyong Shire Council v. Shirt, Judge Mason put the test of foreseeability simply as, even a risk of injury that is extremely unlikely to occur may nevertheless constitute a foreseeable risk, as it is not far-fetched or fanciful. Therefore it can be expected that, knowing the reasonable possibility of Miss Masson's dyspnea leading to irreversible damage, Mr. Peters could rationally have been expected to utilize every pathway available to him to prevent this, including administration of adrenaline despite its own risks.